Pat Bennett.
All right, ladies and gentlemen, I'd like to call the regular meeting of the Wicomico County Board of Appeals to order. At this time, a couple comments. If for any reason we have to leave the building because of whatever, we'd like for you to go out through the doors you came in. When you go out to the end of the hallway there, then you're going to turn right, go all the way out to the end of that hallway and down the steps to evacuate the building. For those that have an interest as well, there is a video TV playing outside. If you go out the room to the left, you'll see that on the wall. We don't want anyone to obstruct the doors. Okay. So at this time, we're going to discuss the findings of fact, which the board is going to review and approve for case WA 2504. Before that, I'm going to introduce the staff serving this evening. On my far left is Colin Harrison. He's our environmental planner and tech support. On his right is our director of planning and zoning, Tracy Taylor. And Janae Merchant on her right, which is a recording secretary. On my far right is Andrew Illuminati, our county attorney. On his left is Clark Meadows, our zoning administrator. Board members serving this evening on my immediate left, David Ennis, Michael Hoy on my far left, William Turner on my immediate right, Jim Morris on my far right, and I am Phil Wright, chair. So now I am ready. Mr. Illuminati, if you would call the first item on the agenda.
Mr. Chair, do you want to entertain the minutes from the previous meeting first?
That's a good idea. All right, so we're addressing the minutes of February 27th, at which time the five of us serving this evening were present.
Mr. Chairman, I had a small change.
Okay.
On agenda item number 5, the last paragraph, it said that, and I emailed earlier today about it, that it said that I voted to approve the special exception, and I actually voted no to the motion. It's a minor issue, but I wanted to make that clear. I wasn't voting to approve it at that point. I was voting against the motion that was on the floor. So I'd like to make that amendment to the.
Okay, it's agenda 5. I got it.
Last paragraph.
Okay. So I'll take a motion that you're making a motion to amend it. So I have a motion on the floor to amend it.
Second.
Second to Mr. Morris. Any discussion? Seeing none, all is in favor, please signify by saying aye.
Aye.
Opposed? The chair votes aye. Passed as amended to change it. We're now looking at the minutes of Thursday, December the 12th. Any other additions, corrections, deletions from the board? Everyone's present, so we have not had any communication from anyone to modify or change any of the minutes. There's no discussion.
Mr. Chairman, I think those were approved the last meeting. I don't think anyone has that. From the December meeting, that was the one case.
Yep. I didn't think it sounded right.
Okay.
Because we're talking about February 27th. So these are the minutes for February 27th. Okay, so we're talking about the minutes for February 27th, which we just modified. Agenda number 6 on the approval.
I move we adopt as amended.
Second. All right, Mr. Turner, motion, second Mr. Hoy. Further discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Opposed? Chair votes aye. All right, now we're going to go on the resolution of decision and findings of fact. If you would please call that, Mr. Illuminati.
Findings of fact, case number WA 2504, Salisbury Riverside West Solar LLC, special exception, minor solar.
Mr. Meadows?
Mr. Chairman, the resolution of decision and findings of fact were prepared by Mr. Illuminati and were submitted for the board's consideration, detailing the action by the board and the request for the identified solar project.
Anyone have any comments, additions, or deletions to those findings of fact as they're prepared?
I have a comment, Mr. Chairman.
Okay, sir.
On page 2, and this is the issue of why I voted against the original motion to deny the special exception. And it's halfway down the page.
Which paragraph?
Okay, let's see. Not the number ones, it'd be the second paragraph, and it starts out, specifically, this district encourages development that is compatible with the existing character. And then if you go down further, let's see, 1, 2, 3, 4, 5 lines from the bottom. It said, therefore, the board finds that the proposed use is not compatible with. And I think at that meeting, my point was that we had been told that the use is, and this is right out of section 225-155, that all such uses have been legislatively predetermined to be compatible. So that's just my objection to the findings of fact, and I just wanted to make that point.
All right, there was,
So just to be clear, I wasn't suggesting at the last meeting that we would, that at some point, I think the applicant had, the facts indicated to me, and just the fact that it's legislatively predetermined to be compatible, but we're in our findings of fact saying it's not compatible. And that's why I voted against the original motion to deny the applicant. I want that in the minutes.
okay.
So that's all I had to say about it.
We found that there were reasons to not approve it, regardless of what Bill just said. Do you see that anywhere in here that,
It is otherwise in there, but the rest of that sentence reads, is not compatible with, and then the adjacent properties or the general neighborhood. The general neighborhood expands beyond just the zoning district. And part of the findings of facts acknowledge that the residential properties immediately adjacent to it are zoned R20. And so
Right.
the general neighborhood is greater than just the zoning district. So that's what that sentence, it's not challenging the finding of the zoning district and the uses within the zoning district, but in relation to the general neighborhood.
so in order to take into Mr. Turner's comments, we need to put that in as an additional, or he just made those for us as we vote for it?
I believe they're just comments as to how he will vote or not vote to approve the
Right.
resolution.
Okay.
But I believe that captures Mr. Ennis and Mr. Morris's position and the others who voted about the general neighborhood,
Right.
which is why it's written that way.
Okay. All right. Any other thoughts, comments, discussion? Seeing none, I would entertain a motion to approve the findings of fact. for the Salisbury Riverside West Solar request.
Chairman, I move approval of the findings of fact and see those as being accurate to how we made the decision.
The findings of fact deny the
Yeah, for the
application.
denial of the application, correct.
Second.
I have a motion by Mr. Ennis, second by Mr. Morris. Further discussion? Seeing none, all those in favor, please signify by saying aye.
Aye.
Opposed?
No.
Chair votes aye. Passed. All right, next item on the agenda, Mr. Illuminati.
Case number WA 2506, DMV Exclusives LLC, in accordance with Section 22567 of the Wicomico County Zoning Code, requests a special exception cannabis business to a dispensary on property owned by Larger Properties 2 LLC and located north of Salisbury at 9156 North Ocean Highway in the C2 General Commercial Zoning District.
The applicant's here. Please come forward. Have a seat. Before you sit down, I caught you. Would you please let Mr. Illuminati swear or affirm, you swear or affirm to Mr. Illuminati's allowing you to testimony before us this evening?
Do you want anyone else who may provide comment at this hearing?
Right, this is just for this hearing, this item on the agenda.
If you're going to speak on this item agenda, you need to stand up now, and anyone in the hallway should come into the main chambers. Okay. Seeing no one else, do you solemnly swear or affirm that the evidence you're about to give in the case now pending before the Wicomico County Board of Appeals is the truth, the whole truth, and nothing but the truth, so help you?
I do.
All right.
Okay, now you may sit down.
Thank you.
We'd like for you to please state your name,
My name is Candace Peters,
your mailing address,
1101 Captain Bell Court, Davidsonville, Maryland.
and please make the statement, I have been sworn or I have been affirmed, whichever you just did.
I have been affirmed.
Thank you. Mr. Meadows, would you please present the staff report?
Yes, sir. Mr. Chairman, this staff report and all accompanying documents are hereby entered into the record. They include applicant's Exhibit A, a letter of proposal, applicant's Exhibit B, aerial photographs which will serve as a site plan, applicant's Exhibit C, the Maryland Cannabis Administration authorization letter, and applicant's Exhibit D, a MCA compliance map. On the back of the materials, you see the property highlighted in blue, fronting on the southbound lanes of Route 13, just south of Foskey Lane. Dr. Peters is here this evening to request a special exception for a cannabis business for a dispensary at the identified property. It's a 3-acre parcel having approximately 200 feet of highway frontage, improved with two 12,000 square foot pre-engineered buildings. The site is developed with paved parking and maneuvering areas and a driveway providing direct access to and from Route 13. The site was originally developed in the mid-1980s and continues to be actively occupied for commercial uses and related activities. The general area is developed with a collection of commercial or light industrial uses. The abutting properties are developed with similar types of businesses. Some single-family residential development is located to the east across the northbound lanes of Route 13. Subsequent to the state's 2023 adoption of the Cannabis Reform Act, further clarified in April of 2024, on August 6, 2024, the Wicomico County Council approved local legislation for cannabis businesses in Wicomico County. This is the first request the board has considered for such a use. Paragraph G, beginning on page 2, sets forth the criteria for the special exception, the first being consistency with the county comprehensive plan. The plan identifies the site being located within a commercial area. The proposed use will be located within an existing building that has been actively maintained as a commercial operation since the late 1980s. The adaptive reuse of an existing building will not require any new development of land and is consistent with proper planning theory, minimizing potential land use conflicts. As a tool to implement the concepts of the comprehensive plan, the zoning code describes the C2 General Commercial Zoning District being purposed for a diversity of economic uses in an area served by county and state roads and highways. The granting of this request is consistent with the comprehensive plan's recommendations for development of the county. Secondly, requires that the use have no adverse effects on health, safety, or general welfare. The use will be located within an existing building with existing services. Any modification of those services would be performed under permits issued by the Health Department. All inventory stored on the site will be offered for sale is monitored and regulated by the state through the Maryland Cannabis Administration. There is no evidence the granting of this request would have any adverse effects on the health, safety, or general welfare of area residents or workers. Thirdly, the use shall be compatible with and have no detrimental effects on the use or development of adjacent properties or the general neighborhood. In accordance with paragraph D of this report and the attached aerial photograph, the site and most other properties in the surrounding area are developed as commercial or light industrial properties. The underlying zoning district is general commercial, and the area has been developed with businesses common to highway commercial properties for many years. This request includes proposed reuse of a previously approved on-site sign. The applicant will utilize one pole sign with framing that is consistent in size with the code's allowances. Fourth, requires that the use meet all the standards set forth for a special exception. The request does not include any request for variances from the terms of Chapter 225. The applicant's aerial photographs, that being Exhibit B, show a paved area providing adequate parking spaces for the proposed use. Number 5, requires that the use be designed to minimize adverse effects on surrounding properties. The request regards reuse of an existing building that has been maintained as a commercial property for many years. The proposed signage is as allowed by code and not excessive for the area. And in accordance with this evaluation, the applicant's proposal and the suggested conditions of approval, this site has been designed to minimize any adverse effects on surrounding properties. Number 6, requires that the use have no adverse effects on public transportation, stormwater management, other public facilities. The request regards the reuse of an existing property. The driveway and maneuvering areas are designed to allow vehicles to exit the site without having to back out onto the highway. Route 13 is adequate in design and construction to accommodate any traffic generated by this use, and there's no evidence the granting of this request would have any adverse effects on the public facilities identified. Number 7, requires that the use have no adverse effects on environmental, archaeological, or historical assets. There are no such assets identified regarding this site or the surrounding area. In accordance with this evaluation, staff finds the applicant has satisfied the criteria for approval of this request and recommends that the board grant the special exception.
Any questions or comments on that staff report
Not
at
for
this
me.
time?
No.
Okay. All right, Mr. Meadows, if you please summarize the suggested conditions if this request were to be approved.
Yes, sir. That's paragraph I on page 5. Number 1, the special exception, cannabis business for dispensary shall be exercised within 1 year from the date of issuance. Number 2, development of the site shall be in accordance with the site plan. Applicant's Exhibit B. Any change in the nature of the use, enlargement of the building, or additional buildings or structures related to this special exception may require the board's review and approval by public hearing. Number 3, the operator of the dispensary shall maintain all licenses as required by the Maryland Cannabis Administration. Number 4, on-site signage shall not exceed one freestanding sign being a maximum of 100 square feet, and B, one wall sign being a maximum of 60 square feet. Number 5, the hours of operation shall be 9 a.m. to 9 p.m., 7 days per week. Number 6, failure to comply with the above conditions may render the approval in this matter null and void. Number 7, the applicant shall obtain county building permits if required and comply with all codes and regulations set forth therein.
Questions or comments on those suggested conditions of approval?
Not for me.
Okay. Any questions at this time from the board?
What have been the prior uses of this facility in the past?
So there is a current business in the structure behind, I think 3 men in a truck. Currently, there was someone who's renting it who did signs or Christmas lights, from what I understand, but nobody is currently using that front location right now.
And so you're suggesting, I guess in your request, maybe, I think I saw it, and that's what's in the conditions, You want to be open 9 to 9
Correct.
for 7 days a week?
Yes,
You feel that necessary on Sunday?
potentially. And those are regulated by MCA as well. So those hours, initially they were only, you could not be open until after 9 p.m. That has been extended, but we don't plan to change that at this point.
Is this essentially a retail facility?
Yes.
The few that I've seen in other counties, there seems to be a real issue with traffic flow on properties, and with Route 13 in front, looks like you have a lot of space, but I think the only thing I would say is please prepare for the amount of traffic you're going to have on this site so that the flow is in and out. And
Yes.
that would have to be, do you have plans for that already in place?
Absolutely. So we've looked at a lot of locations, and I think the traffic flow and the parking situation have been the biggest barriers that a lot of these facilities have had. It's why we looked specifically at this location. I think, there's a lot of space. So, yes, but we do have a plan.
Yeah, because there's really no
Absolutely.
overflow. You're on 13. You got to be, I know they'll make you get all the cars off of
Yes.
13, but
Yep.
that would be my only concern about the.
I just have one question for you. In the report, it says that all inventory is going to be stored on site. I'm curious in knowing what that inventory will be and how you will store it.
So per MCA regulations, it has to be stored in a secure vault. So everything is secured in an area that is not accessible to customers. It's under lock. There is 24-hour surveillance. It is the most secure area of the entire structure, and it's all guided by their very tight regulations. So anything that's sold there that has any type of plant material has to be in this vault every night before we close. If we're closed after those open hours, it cannot be out at all. And that's for the safety of anybody in the building as well as for anybody outside, so they don't have access to it. If there were to be a break-in, they can't get into that area.
So in addition to your product, what else will be stored there?
There could be anything from, you could sell T-shirts or cups or anything could be sold. CBD, which you can buy in a regular pharmacy right now, could also be sold there. So just depending on if it's anything plant-related, it would be in that vault.
Is there any discussion on having to stripe the parking area?
So we already have plans just to make sure that there are areas for handicapped accessible. So those would be, is that what you mean by parking spaces?
Right, well,
Yes.
continuation of that for the general public that's not using handicap. I think as I looked at the property, I don't recall if it's striped on the front, but I'm pretty sure it's not striped on the side.
It is not. So, and we're also speaking with just how to deal with that parking area. Some of it is very well paved. Some of that area is not.
Half of it is and the other half is not.
Exactly. So we are in discussions on what to do and how to make sure that there is access for people who may need assistance. And so all of that will go into whether it needs to be striped throughout or the entirety needs to be repaved. So we're planning for that just as we're going through the negotiations.
And we, under negotiations, who's going to make that decision? Are you the leasee, the leaseor, or,
Or the owner.
right?
It would be one of those
So you're
two,
negotiating with the owner of the property as to
based
what,
on the parking, yep.
but there's no requirements from,
Not from MCA.
Anything requiring more than 5 spaces has to be stabilized parking. Doesn't speak to it being delineated and having marked spaces, but there's adequate space for the required parking.
I'm just feeding off of Bill's comments, so,
There's going to be more than 5 cars there.
yes.
Yeah.
So anything over, it has to be stabilized, but you said it doesn't have to be striped.
There are no requirements in the code that address it being striped or painted.
And stabilized could just be gravel.
That wouldn't be considered as being paved. So there's adequate,
The definition of stabilized,
it's paved, it's not just being stabilized.
Okay.
Half of the entrance is paved, the other half is stabilized, and the occupants of the building behind this, I don't know which way they're going to ingress and egress. Which brings me to one more point. It says that you can have a pole sign and a wall sign. There's only one pole there, and that's already occupied.
Actually, the sign that was on that pole, I think the company that was using that front space took the sign off. So our sign would then replace that sign from,
Took it off today or yesterday?
no,
It
It's,
was,
the former tenants are in the old Chicken Man place, there's Christmas lights and power wash guys, and they took their 10 by 10 sign with them. The hardware for the sign, the structure is still there.
was a sign up there for two men in a truck.
There is another pedestal sign
Yes.
on the
I think
property.
that's the only pole sign I saw. I must have missed it. Okay.
If approved, when will the doors open for operation?
that is a moving target. Because, again, so everything we do goes through MCA. So everything has to be approved, all of our plans have to be approved. So at every point, there are checks. So I wish I could tell you a timeline, but sometime within the next 12 months.
So there's just another step on your road.
Yes.
Okay. Any other discussion, comments from the board? Is there anyone here that has an interest in this request that would like to address the board? Seeing none, the chair will entertain a motion.
So, Chairman Wright, one minor thing, on the front of the staff report, can we make a slight amendment to the zoning there, that it's not A1 and C2 to reflect the rest of the staff report?
Yes, we can.
Thank you.
Someone on the board make that amendment to the zoning.
So moved.
Motion, Mr. Ennis, seconded by
second.
Mr. Morris. Discussion. Seeing none, all those in favor, please signify by saying aye.
Aye.
Opposed? The chair votes aye. Now is the amended agenda number 2. All those in favor, please signify by saying aye.
Motion first?
Didn't I get a motion? No. Okay, I'll take one then.
Got the amendment. Mr. Chairman, I move approval for the special exception cannabis business dispensary, and that is as amended with the zoning to C2, as pointed out, and I accept the staff report as has been submitted, and this would be with inclusion of the special, or the suggested conditions.
I second that.
A motion, Mr. Ennis, second, Mr. Hoy. Now further discussion. Seeing none, all those in favor, please signify by saying aye.
Aye.
Opposed? Chair votes aye. Passed. Thank you, ma'am. Good luck.
Thank you so much.
Seems like
Thank you
it's
to the chairman and the board.
going to be a few time before you can open the doors.
Yes, I appreciate your time.
All right, ladies and gentlemen, this time I'm going to take a brief recess. Okay, ladies and gentlemen, this time I'm going to reconvene the regular meeting of the Wicomico County Board of Appeals. At this time, a little bit of housekeeping. This case is an appeal of an application requesting relief from a zoning determination. The decision of this board is not final and may be appealed to the Circuit Court for Wicomico County. Therefore, it is important that a complete record is formulated. All persons attending a board hearing must maintain order and refrain from disturbing the orderly process of the hearing. In the event of a disruption, I, as a chair, may, in my discretion, clear the hearing room of offending persons or recess the hearing. In order to ensure that the hearing is conducted properly, I want to review what the question before the board is and what the process will be. There is one issue on appeal before the board. That issue is whether the zoning administrator's decision from the Wicomico County Zoning Code prohibits as an accessory use in the A1 zoning district the processing of a poultry litter generated on the property through the operation of a biorefinery facility. The case will follow the following format. The parties will be able to make an opening statement if they wish. Following the opening statement, the county will present its case. It is the county's initial burden of presenting to the board sufficient evidence and argument to justify the order or decision appealed. Upon the county meeting its initial burden, the burden of presenting evidence and argument to the contrary then shifts to the appellant, who shall also have the burden of persuasion. After the parties present their evidence, a period of public comment will occur. If you wish to speak, you will need to provide your full legal name and your address of residence. Simply stating your county of residence will not suffice. You will also need to state whether you have been sworn or affirmed. If you have not been sworn or affirmed, the oath will not be administered before you speak. If you refuse to take the oath, you will not be able to speak. This is a land use issue. Personal attacks will not be tolerated. Repetitive testimony will be cut short. If you provide comment, you are subject to cross-examination by the parties. After the close of public comment, the parties will provide a closing statement. That's if they so choose. Neither the opening statement or the closing statement is evidence. The board will then close the hearing and will deliberate. The board may make a final decision tonight or may reach a consensus, but elect to have staff prepare a draft resolution of decision for consideration at the next meeting. Either way, the 30-day limitation within which a party has a right to appeal a decision of the board shall run from the date the resolution of the decision is executed by the chair. Once again, if you need to leave the building because of whatever happens, go out that door as you came in, go out to the end of that hallway, turn right, go all the way down to the far exit, all the way down the stairs out into the outside. There's also a video screen in this hallway out past the elevator. And having said that, then we're ready for the next case. Mr. Illuminati, if you please call the next case.
Case number WA 2507, Cathuria Farms LLC and International Biorefineries LLC, in accordance with Section 225-154 of the Wicomico County Zoning Code, appeals the enforcing officer with the zoning administrator decision that the processing of poultry litter generated on property through the operation of a biorefinery facility is not an allowable accessory use in the A1 zoning district.
Okay, we'll start at my left, your right. Please state your name, your address. If you're counsel, you do not have to be sworn or affirmed. Before I do that, we need to swear or affirm. Jumping the gun. So anyone who has any interest that may have an interest in speaking to the board this evening, obviously everyone in here is not going to have the opportunity to do that, but if you have any interest, now's the best time to do it instead of later when you're going to be standing up by yourself and everybody's going to be looking at you.
If we can just wait a sec, the director is going to check to see the overflow wants to be present. Showalter, if your client's going to testify, he needs to be sworn. Okay. All right. Looks like everyone from the hallway who's interested has come forward. Do you solemnly swear or affirm that the evidence you're about to give in the case now pending before the Wicomico County Board of Appeals is the truth, the whole truth, and nothing but the truth? So help you? And for the record, Mr. Chair, Mr. Meadows was sworn in from the previous case, and it carries over.
So noted. Okay, so now, starting on my left, your right, state your name, address, and if you will, what you're representing. Yes, sir.
Good evening, Mr. Chair. My name is Zachary Kelsey from the law firm Nidell and Mays. I'm joined by my co-counsel, for Housekeeping, Daniel Diamond. We represent the interested parties: Greg Talent, Julia Talent, Aaron Talent, Tyler Talent, Daniel Dean A. Hall, Daniel Hall, Terry Sell, Jill Sell, Raymond Dillon, Brandon Fletcher, and Dale Smith.
Could you give us your address?
My address is 4111 Connecticut Avenue Northwest, number 302, Washington, D.C.
Have you been sworn or affirmed? No, you're counsel. Sorry, jumped the gun. Okay. You are with these people, correct, sir?
No, I'm not.
Okay. All right, sir.
Lawrence Scott, I'm with the law firm MDSW Law. I'm a co-counsel to Ryan Showalter, representing Mr. Cathoria.
Mr. Chair, the lady before Mr. Scott is an attorney, and she needs to identify herself.
She's here by herself?
No, she needs to identify
Oh,
herself.
okay, I'm sorry.
I'm Danielle Diamond. I'm with Diamond Legal, and I am here with co-counsel Zachary Kelsey of Nidal and Nace from Maryland, and I'm the attorney that was admitted pro hoc vice and representing the people that Mr. Kelsey just announced.
And my address is 230 Roxeter Drive, Arnold, Maryland, 21012.
Thank you, sir.
Rajneesh Kathuria. My address is 8665 Hickory Mill Road, Salisbury, Maryland.
Have you been sworn or affirmed, sir?
Sorry?
Have you been sworn or affirmed?
Yes, sir.
Okay. Which was it?
Sworn in.
Sworn. Thank you, sir.
Good evening, Ryan Showalter, McAllister, Detar, Showalter, and Walker, 100 Northwest Street, Easton, Maryland, appearing on behalf of Cathoria Farms and International Biorefineries, LLC.
Thank you, sir.
Good evening. My name is Erica Witz. I represent Wicomico County Department of Planning and Zoning.
Address?
115 Broad Street, Salisbury.
Thank you. Mr. Meadows?
Clark Meadows, zoning administrator, 125 North Division Street. I have been sworn.
Thank you, sir. Okay. Mr. Illuminati?
Called the case. If the parties want to present at this time, obviously, Mr. Showalter and the interested parties may want to wait until their time to make opening statements, or all parties can make opening statements now. You want to reserve?
So do you have a preference on whether, well, I guess the county's going to definitely make a statement.
Correct.
So if the supporting part, or the supporting parties to upholding the appeal could do that now.
Sure.
And then the appellants could do that, and then the county can do that.
Appellants can do it at the beginning of their case. The county can go first, or the interested party could go first, because the county needs to present its case to meet its initial burden.
We're talking about initial statements.
Yes.
So it doesn't have to be one or the other. Are you suggesting that the county makes the initial statement now?
The county should go first.
Okay, thank you. Ms. Witz?
Thank you very much. So we are here for an appeal of the decision of the zoning administrator based on his determination that a biorefinery facility is not an allowable accessory use in the A1 agricultural zoning district. So to meet our initial burden, the county will present the staff report through Mr. Clark Meadows, and that will describe the basis for that decision, including the application of the definitions within the zoning ordinance that are germane to the operation of a biorefinery facility. Once we meet our initial burden, the appellant's burden to persuade this board is very high. And to refute any assertions that the appellant makes, Mr. Kia Safai, the county's chief building inspector, visited the property. He will report to you all what he observed. He will have photographs. And then I do ask that you keep in mind the burden that the appellant has. In order to overturn the decision of the zoning administrator, you would have to find that his decision was either clearly erroneous, arbitrary, or capricious, or incorrect as a matter of law. Thank you.
All right, are you going to go through the staff report?
Yes, sir, I would
Yes.
present staff.
I mean, are we at that point now?
Unless, is an interested party the attorney's going to make a statement now if they choose, or not entirely sure what the order is?
Yes.
Okay.
Okay.
Yes.
All right.
Thank you. As I mentioned before, I'm here with co-counsel Zachary Kelsey, and we understand that the board has procedural rules that you need to follow, and in the interest of time and expediting the process, we intend to have maybe one or two of the interested parties give testimony, and then I can summarize the rest of their concerns for the record after that. The interested parties, the case we'll present is that they support the county's determination that the biorefinery is not an allowable use or an allowable accessory use in the A1 agricultural district, which we believe is designed to protect agriculture from incompatible developments. It's our position that, or our client's position, that the biorefinery is an intense industrial use that's not incidental to an allowable agricultural use, and we believe they have very viable concerns about how the intended use of the property will negatively impact them. We'll have, like I said, 2 or 3 of our clients provide testimony, and I will then summarize their concerns. And we also have a packet that we'd like to provide to the board with various exhibits, and we also have copies for all the parties here that just sort of back up the reasons why our clients have these concerns. And overall, we just want to present a case that will hopefully not provide anything duplicative of the county, but just additional information that will support their determination. And overall, what you will hear are the concerns of the neighboring residents that are directly adjacent to the property or within 200 feet, and our plea to the Board of Appeals to affirm the enforcement of the county's ordinance to protect the agricultural area. And as an aside, as you know, I'm not from here. I'm admitted pro hoc vitae from a different state. But I have to say that with agricultural areas like this, we want to protect agriculture, and people want to protect farming. And that is a common cultural aptitude that is across the country. But I will say that in doing that, we do provide them exemptions and less stringent regulations. And there are a lot of heavy industrial industries that want to be determined to be agricultural, so they don't have to abide by more stringent rules and regulations and exemptions under the law. And so this is a pattern that I've seen in my work across the country, and I think in this case, the county has a situation that's similar to other places across the country where our rural areas have become industrial sacrifice zones of pollution and other harms to neighbors. And so what your county staff has done is rightfully made a determination, and they were able to draw a line where the line needs to be drawn. And thankfully, you have a county staff that realized that decision needed to be made, and we are going to ask that you affirm their decision that the biorefinery should not be allowed at that location.
Thank you. You ready, sir?
Yes, sir.
Okay.
Good evening. Thank you for your time. So the issue in this case is not a popularity contest or vote. It's simply a question of interpretation. And we understand that there are or may be concerns about industrial refining. That's not what this case is about. This case is about agriculture, and we're going to explain to you why that's the case, why the limited nature of what's proposed on this property is entirely consistent with the definitions and provisions of the county code. Perhaps misinterpreted or misconstrued, nothing personal here at all, but we believe that the activity that's proposed, the processing of poultry litter, is simply a question, in this case, what the reaction you're receiving, the arguments and criticism you're seeing, those are reactions to a technology, but not to a use. And the use that we're proposing on this property is a use that's occurring on poultry farms throughout the county, on livestock farms throughout the rest of the state, and to a lesser extent in this county. And we believe it's entirely permitted by the county code. We believe it is permitted by right, and even if the county finds it's not permitted by right, we believe it is permitted as an accessory use to agricultural operations. And we will walk you through the definitions, the use table, explain what the use is, and explain why that is the case. And respectfully, we think the only conclusion that you will make at the close of the evidence is that in this case, the county made an interpretation that is not aligned with the code, and it should be reversed. Thank you.
All right, Mr. Showalter. Okay.
At this time, I would ask that Mr. Meadows approach the witness stand next to Mr. Illuminati and present his staff report.
Can everyone hear all right? Okay. Yes, sir, Mr.
Ready,
Meadows.
Mr. Chairman. Mr. Chairman, this staff report and all accompanying documents are hereby entered into the record. I'm going to go through the exhibit list for the planning office, that being the staff report, planning office Exhibit A, planning office Exhibit B, the notice letter dated March 5th, 2025. Exhibits C1 and C2 are applications for the public hearing, C1 being dated January 28th, 2025, C2 being signed February 17th, 2025, including, the appellant's revisions. Planning Office Exhibit D, the legal advertisement publication dates being March 11th, 2025 and March 18th, 2025. Exhibit E, Meadows letter dated 12/26/24. Exhibit F, Maryland Department of Agriculture correspondence dated March 12th, 2025. Exhibit G, the Hurley Farm Bureau letter of March 12th, 2025. Exhibit H, site photographs being H1 through H19. Exhibit I, building permit application number 7673. Exhibit J, building permit number 31207, not included in the staff report, but submitted just this week, is a Planning Office Exhibit K, University of Maryland package dated March 22nd, 2025. I believe all parties have a copy of that correspondence. Also included in the staff report is the appellant's exhibits, the notice of appeal, a letter provided by Mr. Showalter dated January 22nd, 2025. The staff report summarizes and sets forth that the staff advised Mr. Cathuria that the processing of facility and biorefinery on the identified property was not an allowable use or consistent with the terms and conditions set forth in the county zoning code for an allowable use in the A1 zoning district. And in accordance with Mr. Showalter's letter dated January 22nd, 2025, the applicant appeals the decision of the zoning administrator. The appeal was filed in a timely manner. The appellant's position is that Cathuria Farms LLC, International Biorefineries LLC, that the processing of poultry litter generated on the farm through the operation of a biorefinery facility is allowed as an accessory use in the A1 district. The enforcing officer's position is as such. On August 1st, 2024, Mr. Cathuria applied for a Wicomico County building permit to construct a 45 by 165-foot agricultural storage building as a replacement for an existing on-site storage building. The county issued the permit on the basis of the intended use listed by Mr. Cathuria on that application. In November of 2024, it came to the attention of the planning department that the proposed storage building was intended to house a biorefinery to process poultry litter. Staff followed up with a phone call to Mr. Cathuria and a site inspection to determine the intended use of that building. That use was confirmed by the chief building inspector as being significantly different than the intended use listed on the permit application. And the staff at that time issued a stop work order, that being effective December 3rd, 2024. On December 5th, 2024, Mr. Cathuria came to planning office and met with staff to discuss the details of the intended use of the building. Mr. Cathuria affirmed that poultry litter solely from his farm would be processed to create biochar and biofuel. He explained that the biochar would be bagged on site and utilized by the Maryland Department of Agriculture, and the biofuel would be sold for profit by himself. Both products would require to be trucked off-site. At the conclusion of the meeting, Mr. Cathuria was informed that the stop work order would remain in effect until staff was able to determine an official zoning designation. On December 26, 2024, subsequent to that meeting with Mr. Cathuria, the Planning Department authored a letter, that being Planning Office Exhibit E, to the appellant expressing the department's determination that operation of a biorefinery to process poultry litter was not an allowable use in that district. Chapter 225 of the county code includes definitions of agriculture or agricultural, and the definition sets forth several points and examples of generally accepted practices, that being livestock, poultry, fruits and vegetables, and similar activities. Related buildings, appurtenances, and all uses classified as agricultural are also included in the definition. The code specifically defines agricultural products as cultivated plants or animals that have been harvested and excludes processed products. The applicant's own notice of appeal affirms that the proposed use is to be, quote, processing of poultry litter, close quote. In the zoning code's definition of use, a distinction is made between the principal use and an accessory use. The principal use would be the primary purpose for which a property or building thereon is designed, maintained, or occupied. Use and development of the subject property is for a poultry farm having related dwellings and other structures, and the property is assessed by the state as being agricultural. Accessory uses are defined as those being, quote, customarily incidental and subordinate to the principal use of a lot or the main building thereon, and located on the same lot as the principal use or building, or on an adjacent lot under the same ownership, end quote. In consideration of how the zoning code defines an accessory use, it is observed that the inclusion of the word customarily, implying that the use or practice is ordinary, frequent, or common. The Planning Department is unaware of and has not issued any authorization for any other poultry litter processing facility or biorefinery in Wicomico County. In summary, and as enumerated below, it is the zoning administrator's decision to identify the processing of poultry litter generated on the property through operation of a biorefinery facility as being either a principal or accessory use. It is a use that is not allowed in the A1 agricultural zoning district because, one, pursuant to section 225.25 definition of basic terms, the county zoning code, the processing of poultry litter generated on the property through the operation of a biorefinery facility is not recognized as an agricultural use. Number two, pursuant to section 225-25 definitions of the county code, poultry litter is not recognized as an agricultural product. And three, pursuant to 225.25 definitions in the code, the processing of poultry litter generated on the property through operation of a biorefinery facility is not recognized as either a principal use or an accessory use. Based on this evaluation, staff's determination and recommendation is that the board uphold the zoning administrator's decision that the processing of poultry litter generated on the farm is not an allowable use in the A1 zoning district.
And has the staff report been received as an exhibit and all the attachments to it at this point? Yes.
These we've got those already identified.
Correct.
Okay.
Mr. Meadows, I want to just take you through some definitions and also take your attention to the December 5th meeting with Mr. Cathuria. During that meeting, I believe he stated to you that 2 products are produced during this process. Do you recall that?
Identified biochar and biofuel as being those 2 products, yes.
Okay. Do you recall what he was planning on doing with the biochar?
His description was that the product was going to be used by the state of Maryland on the Nanticoke Road farm.
And what about the biofuel? Do you know what his intention was for that product?
I seem to think that he was not expecting a big yield of biofuel, but eventually, when there was enough product, that would be trucked off-site and sold as a separate product.
Going through the definitions of the county zoning code, I'd ask that you, if you are able to, read in its entirety the definition of agriculture or agricultural.
Yes, and that would be Section 225-25 of the County Zoning Code. Agriculture or agricultural is the raising of agricultural products, including livestock, poultry, dairy products, farm crops, fruit, vegetables, timber, cultivated plants, and nursery stock, whether for gain or otherwise. Agriculture shall include the farming or culturing of aquatic plants or animals, or both, in natural or artificial water bodies or impoundments. Agriculture includes horticultural, chemical, or general farming, truck gardens, cultivation of field crops, and in general, all uses commonly classified as agricultural, and the related building structures and appurtenances necessary to carry out the aforementioned activities.
And can you do the same for the definition of agricultural products, please?
Yes, ma'am. That's the same section of the zoning code. Agricultural products are defined as cultivated or raised plant, animal, or marine life that has been harvested. This does not include processed products.
So in your professional opinion, is biochar and biofuel, are those processed products?
Yes, by Mr. Cathuria's own description, it is a result of a process, yes.
And can I ask you to inform the board of the definition of an accessory use?
Again, that's section 225-25, definitions of the county zoning code. An accessory use is a use which is customarily incidental and subordinate to the principal use of a lot or the main building thereon, and located on the same lot as the principal use or building, or on an adjacent lot under the same ownership.
And I think you may have touched upon this in your staff report, but are you aware of any other poultry farm or any other property in A1 where this type of processing is occurring?
I'm not aware of any other similar facility in the county, no.
Turning your attention to some of the correspondence that the department received from the state, I believe it was from the Department of Agriculture, in relation to the grant that Mr. Cathuria received. Do you know if the state contacted the department to inform the department about the grant?
No, ma'am.
Which department?
The Department of Agriculture, the state.
No,
The Department of Planning and Zoning.
yes, thank you.
Department of Planning and Zoning received no information from MDA regarding Mr. Cathuria's operation. Prior to receipt of this letter dated March 12th, I'm sorry.
Does that letter address zoning?
It does not. It addresses the technology and explains from the MDA's point of view benefits of the technology. But local zoning is not addressed.
And turning your attention to Exhibit K, the letter dated March 22nd, 25, that's from the University of Maryland. I wanted to ask, does this letter in any way address zoning?
No, ma'am, no discussion or consideration of the local zoning in that letter.
Those are the questions, all the questions that I have for Mr. Meadows at this time. I don't know if now is appropriate for cross-examination, or if you'd like me to call another witness.
Now is appropriate for Mr. Showalter to do cross-examination.
Mr. Meadows, the county doesn't dispute that poultry production is permitted by right in the A1 district, correct?
No, sir.
And does that use require any special approval, any use approval from the county?
It does not. There are standards that have to be met with regard to property